and the best lawyers in America. Clay is a frequent lecturer speaking throughout the Southeast on the topics of employment law, industrial accident litigation, and workers' compensation. He is admitted in many courts in this area, also has a volume of memberships, but he interestingly is on the State of Alabama Department of Industrial Relations Legal Advisory Board. Fred Farrell is a shareholder in the Huntsville office of Wilmer and Lee. He has been selected multiple times the best lawyers in America and Alabama super lawyers. He has received an AV rating also in legal ability and ethics, ethical standards from Martindale Hubbell for more than a decade. He's also a frequent speaker at state and national workers' compensation seminars. Fred is also very active in his community. He is co-chair of the Northeast Alabama Fellowship of Christian Athletes. He's on their advisory board. He also has served as a Young Life volunteer leader. He served as Chief Justice of the Student Court at Alabama. He was selected to honorary groups including ODK, Mortarboard, and he attended undergraduate school, no kidding, on a debate scholarship. Ladies and gentlemen, please welcome Clay and Fred.
Thank you very much. Thank you. You know, after hearing that, I mean, what you're going to be thinking when you hear us talk is you should know better. But Fred and I are charged with giving a case law update. And there are a couple of things I want to say about normal. One is we're not really accustomed to doing that because it's way too much structure for us, but we're going to give it a shot. The other thing is that I would say is that there's not a whole bunch of cases that are being handed down regularly by the Alabama Court of Civil Appeals and by the Alabama Supreme Court. So what we're going to be doing is sort of picking our favorite cases that are lusted for certain points over the last few years and talk about that. But what we're going to do, the theme we're going to try to go back to as we're talking about cases, and even after we finish talking about the cases, is how does that fit in? How does that fit in with what our strategy ought to be as claim professionals? And so that's kind of what we're going to be talking about. I've got that right, Fred?
You got it. Okay. You want to kick it? All right, here we go. By the way, I cannot let this moment pass without recognizing the most outstanding legal secretary in the history of the state of Alabama. She's been with me almost 30 years. Cindy Kramer. Would y'all give it up for Cindy Kramer? I'm sorry, moment of personal privilege. Okay, by the way, she has given me, she has left with me copies of handouts. They're $4.95 each. And no, they're up here. If y'all don't come get these after this is over, she's got to carry them back to Huntsville. So come up and grab one. They're great to read when you're on vacation. If you need something to put you to, keep you awake at night, they're perfect. What a great week. You know, we're always talking about paying too much on claims. How about Auburn University? Up to $46 million on ex-coaches. As most of y'all know, I'm married to an Auburn girl, and I went to Alabama. I remember, there you go. You got change? Okay. Just keep it. We're married, and you know, I was just over there gloating about Hanson and that they spent more on coaches than we spent on Saban. And I'm like, this is you know, and she goes, I've had it, Fred. What do you love more, me or football? And I thought a second, I went, you talking college or pro? You know, I remember when we were dating, I was over at Alabama, she was over at Auburn. I remember calling up and I said, hey. She picked the phone and said, hello. And I said, will you marry me? And she said, yes, yes. Who is this?
Okay, he has been telling those jokes for 20 years, and they are still funny for some bizarre reason. What is really funny is that he keeps telling them, you guys keep laughing at them.
I know, I can't stop telling them. Okay, let's kick it off. By the way, one other theme, and I'll let Clay, you know how we just go on this, by the way. I get stretched here. We're just going to get going fast. Here's the good news. No matter what happens, we stop at 2 o'clock sharp. No questions, no nothing. If you got a question, you can catch us out in the hall. We're going to end it too. We're running this sucker on time.
Now, if you get a question in edgewise while we're talking, Have at it. That's fine, but we are going to end on time.
Oh, you think I need more power?
He doesn't need to be louder. He doesn't.
Okay.
Okay.
Okay, just as to kick it off, then I'll let Kelly introduce our first issue of new cases. I'm remembering law school a long time ago. I gave you everything in my resume except what year I graduated. But a long time ago in a land far away in Tuscaloosa, Gorman Houston was on the Alabama Supreme Court. His daughter was in our class. They issued a decision, and several of the young lawyers in the thing were, that's just wrong. They made a mistake. That's not the law in Alabama. And I remember he looked over at Millie and looked over everybody and he said, it is now. And that's kind of the way it is with workers' comp. It's changing, it's evolving, it's emerging. And so I think Clay and I want to talk about the cases with the strategy that might go with them. So Clay, you want to kick us
Sure. All
off?
right, absolutely. So we're going to start with exclusivity, okay? And there are a couple of cases that are sort of important to focus on with respect to exclusivity. One, and in my handout is ex parte Lincare. I like this case because I have a really twisted sense of humor, okay? But it is also illustrative about the power of the exclusivity provisions of the Workers' Compensation Act. So even intentional willful injury does not render the employer liable, okay? Does not. Now, co-employees maybe, all right? So in this case, you've got a supervisor, okay, who gets a letter of resignation from an employee that basically says, I'm quitting because you have made this a very difficult working environment. Whereupon he beats her up. Okay? Now, I can see that everybody doesn't have the sort of twisted sense of humor I do. I think that's kind of funny in a really weird way, but there is no cause of action against the employer under those circumstances. Would they have a cause of action against the person that assaulted the injured worker? Absolutely, but no tort claim against the employer. Now, the only sort of wiggle room, and this has been very robust. So, but there's been a recent case a couple of years ago, the McCoy versus International paper. So you've got somebody that's got a terrible burn injury in the line and scope of employment, and the employer afterward engages in a series of in some conduct that independently, arguably, caused some separate and distinct injuries. Okay, they did not take the employee to the ER immediately, even though he had full thickness burns. Rather, they stopped at a pharmacy and got some topical cream and decided that would work first. So the Court of Civil, the Alabama Supreme Court says that those actions are outside of the scope of exclusivity. Fred?
Yeah, and let me mention, you sure that's not too loud? I don't want to burst your eardrums. Okay, here's the deal that's happening. You got to think through this stuff. If you're going to deny workers' comp benefits, you can sometimes take a chance of getting your insured or your fund members sued from tort. Okay, I've got one right now where we had a fight in a kitchen. Okay, we have a fight in the kitchen and we say it was due to horseplay and we're going to deny workers' comp. Well, then we get a lawyer for the plaintiff, and he writes and says, okay, if y'all won't pay workers' comp, we're going to sue you and demand a jury trial for compensatory damages against this company because you're saying it's not workers' comp. So you got to begin to think out. One of the first questions I ask when I get a new claim in is, if I'm going to deny a claim, is there any chance this could turn into a tort claim? For example, is there some negligence going on here? And Clay's exactly right on these fight cases. There's a whole bunch of stuff going on. The big case that started all that years ago actually happened to be one, I know about it because I was involved with it, Beverly versus Ruth Chris. But two guys were arguing. The plaintiff said, and they got into a fight at the shrimp bar when they were working at Ruth Chris here in Birmingham. And the plaintiff said that they were fighting over the arrangement of the shrimp. One of them didn't like the way the guy was laying it out. And which might be compensable, but we said no. What we found out was they were fighting because they both like the same cook. So she was pretty attractive. We had a couple guys there back there, and so that's what we said. We said it was personal. And we got a summary judgment, went up on appeal, and went on and on. But that case set the standard. It said if the fight is for a personal reason, you don't owe it. If it's for a business related reason, you probably do owe it. So there's your distinction on fight cases, but be careful because you're snake handling if you deny a claim right now, because the plaintiff's attorneys are all looking for ways to sue your insureds and your fund members and your case nurses and you for something besides workers' comp. Clay?
That's correct. And I will say, you know, the jury verdicts here in Alabama, as across the country, really have taken a huge spike. So whatever we can do to stay away from juries is a good thing for us to do. So, but the question, the real question is does the injury arise from the employment or not? And if you're saying it's not compensable in the first place, then that can theoretically expose you to some tort liability. An example of this would be that Drury Hotels case that came down recently, where somebody is physically, an employee is physically assaulted, criminal act, okay? And there's a good argument that the criminal acts may not be compensable, but it could give rise, and it was mentioned in this case, that could give rise to tort liability for failure to protect that injured worker, right, Fred?
That's exactly right. And let me, yeah, we've got a bunch of them. I've got shooting, and it's really our society, as everybody knows, is becoming more violent. I've probably got a half dozen cases right now with shootings at work. And the question is, are they compensable? Are they not compensable? And then is there third party liability? And might the third party liability be against your own insured? So I'm just saying, you're snake handling when you get into these violence cases, be real careful with it. It's as an example of Clay's talking about jury. Let's take a typical death case in workers' comp. Maybe you'll owe $500,000, $500,000. I just heard on the news this morning up in Anniston, $6 million wrongful death case against an ambulance company, 6 million, not 500,000. So you have some obligations to your insured. You got to weigh all that into play. Switching gears. Let's talk a second about scheduled injuries in a new case. If you've got my handout, I'm gonna let them go for $395 now if you still don't have one. But if you got my handout, the first case is a 2021 case, Turner versus Baga. This is new stuff. And the court reversed somebody saying it was a scheduled injury. And let me clear one thing up right now. I hear this all the time. Shoulders are not scheduled injuries. Okay, just keep that in mind. Don't make that mistake. Don't even waste time going down that dead end street. But
there are some states, there are some like
Yeah.
Georgia, for example, but in Alabama, it's of injury to the body as a whole.
take several. Yeah, I'm telling you, Cindy's going to take these back. Okay, now let me tell you this Turner case. Here's what they said. They reversed. The Court of Civil Appeals reversed on something. There was an arm injury because depression existed and depression took it out of the schedule. So watch these cases now. Have you noticed that we're getting all these complaints? There's one lawyer in particular. I won't tell you his initials. Well, I'll give you his initials only, but they're George Moore in Huntsville. And George, every complaint he's filing, he's adding a mental aspect to it. Well, that takes it out of the schedule potentially. It opens you up to Medicare exposure if you start paying a mental bill. So you got to be very, very careful. But watch these things. This is a little bit of a twist. Usually they said pain takes it out of the schedule. Now they're taking mental illness and saying that'll take it out of the schedule. Clay?
Well, and this is a routine strategy of plaintiff lawyers, okay? And I don't blame them necessarily. So you've got a schedule injury, whether it's to a leg or to arm or what have you, that has a defined value. And the only way to really increase the value of that claim significantly is to have it viewed as an injury to the body as a whole. You can do that with pain, complex regional pain syndrome, RSD are examples of that. And what we're seeing more and more often is that the lawyer is trying to posture the case for a mental injury. Now, just because the lawyer is telling you that their client needs to be evaluated by a mental health professional does not mean that that's something that we ought to do or something that we owe. I think strategically, what we would look for is we would be looking to the ATP to be making that call. And if the ATP is not making the referral, or the ATP is not identifying a mental injury that needs treatment, then I think we're pretty well justified not independently taking on that responsibility ourselves with very unpredictable results. Fred, do you agree with that?
Yes. All right. The price is going up to $5.95 due to inflation. So I'm just letting you want to get them now. All right. Here's another strategy. All right, listen to this one. Another new case, 2021. Clay knows more detail about this case since I know that he handled it. This was all the way to the Alabama Supreme Court, but the court basically did not go along with the contractual agreement between the worker and the
Fred
employer.
would always pick my losers, okay, to announce to everybody. But,
Well, I didn't tell him you lost.
what-
And now, look, okay, everybody knows now. Here's the deal. One thing you need to be doing is checking in every case you have for contracts between your insured or your fund member and whoever they were working for or with, because everybody is throwing these indemnity provisions on the back of their paragraphs, on the back side of these things. And you can get totally screwed over by an indemnity agreement. We've got probably a dozen cases right now where we're litigating about the indemnity agreement, about who owes who and how it's worded. And they didn't even know they had signed it. You know, they can't get the job unless they sign this stuff. So they get hooked on for workers' comp liability, or reverse, some of them, now the subs are bearing it on the back of their contracts and handing it to the general. So we have battling indemnity forms, but you need to always ask, I think now as a new checklist, part of your due diligence on a workers' comp claim, ask, do you have any contractual agreements with anybody you were working for or with the employee? Because that may change the law depending on what those agreements say. Clay?
Correct. And that particular case dealt with a venue or a jurisdiction selection clause where the injured worker to be signs a document that says these workers' compensation claims shall be handled under the laws of Indiana or whatever. Okay. So, you know, I will say this about that. The final word probably still on that issue still needs to be addressed by the Alabama Supreme Court. They really declined to really address it. They did have dissenting opinion, which another justice signed on to, which suggests they wanted to sort of revisit that issue, but unfortunately not in my case. Fred?
Agreed. Next case, number 3. This is ex parte standard manufacturing. These are all new cases. This is a case about post-judgment motions for contempt. And we just need to park here a second because Clay and I have both seen this. I just had somebody, these are almost like the new outrage. Somebody has got a claim that's 10 years old. They don't believe the person needs more medical care, so they just had a judgment before it. And this is the perfect storm. If you had a judgment in the past that left medical benefits open and you decide to cut off medical benefits, you can get sued for contempt. The plaintiff's attorneys are talking about this at the trial lawyers' meetings. I've heard them stand up in front of the crowd and say they want to start demanding jury trials. They want to ask for punitive damages. They want an attorney's fee award. And I just had one. I've said this to several Labor Department seminars, and somebody who was sitting there called me and they just got sued. And I said, what did you do? And they said, well, you know, I haven't been paying the medical care, but she doesn't need another doctor. Her past doctor quit. And I said, well, who made you the judge of that? You can't do that. You have got to do this properly. Now, we had a case several years ago. I'm going to brag on the home builders a second. It was Huey versus Stutz. And that was a case where they called me and they said, somebody's got an injury at the L5 level, meds are open. Now they want surgery at L3, something like that. And they said, what do we do? And I said, whatever you do, don't just deny it because you're going to get sued for contempt. We'll go to the judge and ask the judge to decide. And then we get to put on a case and decide it's related like a regular case. That particular judge, Jim Smith, who I love to death, but is very plaintiff oriented, ruled against me and awarded attorney's fees. But we took it up to the Court of Civil Appeals on a 5-0 decision. They reversed. And they said, how can the insurance company or the fund be held in contempt if they ask the court for instructions? And so now the latest thing I heard from Larry King, who a lot of y'all know, is it's a race, and I agree with him, it's a race to the courthouse. If you cut off the medicals on a settled claim, and they get to the courthouse before you, they file a contempt charge, and then they claim the only reason you're paying it and trying to correct is because of their charge and they want all their fees paid and they want some damages against you. If you file first, then you have the defense available to you that we haven't made a final decision. We're asking for instructions. But remember, the perfect storm is an open medicals case where you had a judgment that they can sue you for contempt. Clay?
Well, and that's true. This may have actually been one of the most important cases in the last 10 years or so, because there is really, I mean, the number of outrage cases that we're seeing has dropped a lot. We do occasionally see them, but not very often. They've been replaced by contempt actions because they're much faster and they're much easier. Okay. And you already have an order in a settled claim, and sometimes it could be 2 or 3 decades old even, that requires you to provide medical treatment in accordance with the act. And so all of a sudden, if you don't do that, it's up to then a judge and wherever to decide whether or not you are in contempt. And if that judge finds that you are, then the Alabama Rules of Civil Procedure permit that either party can at that point ask for a jury to be impaneled to address punitive and compensatory damages. We would certainly not do that, but that is not a good place to be. And so within a matter of weeks, you could find yourself in a situation of having to explain to a jury why they shouldn't be sending a message. So Fred is absolutely correct. It is a race to the courthouse. And if we ask the judge in good faith for some instruction or whatever the issue is, we're basically bulletproof. Now, the good news is that with the rise of benefit review conferences, all right, which are not a judicial finding, although they are an approval of the settlement, okay, and they are valid and enforceable, it's not an order of the court that is requiring you to act in a certain particular way. There's going to have to be legal action after that. And so I think the long-term view of this is that you're going to see a fewer and fewer and fewer contempt actions because there are just going to be fewer of those cases out there. Now, there are, even in today's world, there are, and this is part of strategy, okay? There are some cases where you want to have the settlement approved by the court nonetheless. One is where you have the claimant that's got a child support lien or you're on notice of a child support lien, okay? Because we need to have that judicially addressed in connection with any settlement. We need to be including some identification language in the settlement documents and so forth. The other situation is if you've got a significant Medicare issue, you want to have those cases approved by the court, okay? Now, it can also help you with an MSA, and here's how. So I settled a case this week, okay? Highly disputed case, okay? The fundamental issue about causation of the accident and compensability itself. Terrible damages, PT, no question about it, involves a stroke, okay? So did the stroke cause the accident? Did it not cause the accident? Okay. What is the sequelae or the damages flowing from that accident? So there are medical records that are sort of all over the place and make a lot of them very specific findings, some of which are in conflict. What if you settle that case, you want to have that court approved because you can include evidence to the judge so that the judge will then, because remember what the judge's role is. The judge's role is to act as a finder of fact in part and to make a determination about whether or not that settlement's in the best interest. And part of what is going to be happening in that process is the judge is going to be looking at the evidence and making determinations on those relevant factual and legal issues and putting that in there, okay? That can, to a great degree, shape what an MSA is going to look like in the future. Fred, do you agree?
I do. And that leads me to another point. Let's talk about judges and claimants just a second. I've got one, I deposed somebody on this past week. They've denied the claim completely, but I'm telling you, I deposed that person and they are so credible. It's a 50-year-old individual who has never had a claim before in his life. He's been doing physical work. He's been with them for years. And he says his back hurt. Yeah, there were no witness. I know that and all that, but he does have now a diagnosis. And I'm like, a lot of this is human behavior. How is this guy going to come across? If this guy had 5 prior felonies and 10 prior workers' comp cases, it'd be a different case. But you got to look at the claimant to try to figure out what the probabilities of success are. That brings me to the 4th case, by the way, which is City of Guntersville versus Looney here in the handout. This is another 2021 case. These are all new. And there, the court said that even though a guy was back at work, if he just subjectively says, I can't work, he got a permanent total award affirmed. Okay, permanent total, even though the guy was trying to be back at work. Now, why did that happen? That happened because of his credibility and, of course, who the trial judge is. And the number one thing, Many attorney, Clay and I also speak at the meetings for the attorneys. It's just a consensus among the plaintiff and the defendant's bar that the two main factors in a workers' comp case is who's the judge and who's the plaintiff. Because there are some judges, as we told the story before, it used to be over in northeast Alabama. We had two judges that rotated cases every 12 months. One of them, Judge Adderholt, Robert Adderholt's dad. He wouldn't give any permanent totals. He wouldn't give anything. The other one, Judge Mayhall, he would give everybody permanent totals. And so if you were defending one and you had Mayhall and it's December, you'd have a stroke to keep from going to trial. All you got to do is get to January and it switches to Adderholt. And the whole value of the case starts. I was over in Decatur one day and we're sitting there, and I don't care how much you've spent on all the vendors out here. It all hinges down to that day of trial. We go into the trial and there's a judge up there that gives everybody a permanent total. But you know what? One of the other judges is sick. And in walks Tom Younger from Huntsville, who's retired and never finds anybody hurt. And he says, I'll take some of these cases over. All of a sudden the plaintiff's attorneys are going, I'll take the 10. I'll take the 10. And see what it changes the value of the case. So one thing you want to make sure is make sure you know the territory. It's a basic for those of you that served in the armed forces. We appreciate your service, but you know that it's very important to understand your surroundings. Who's the judge and how does the plaintiff come across, Clay?
And also remember that the judges are elected as in connection with partisan elections. So you've got Republicans running against Democrats, Democrats running against Republicans, and depending on where you are, they may win as a result of that political affiliation is possible. Okay. We've got a lot of terrific judges in this state, but they are in part connected to politics. And sometimes in some jurisdictions, that may influence what is going to happen, particularly if you've got some local counsel there representing the injured worker that has a close personal relationship with that particular judge. Okay. All right, we're going to talk about another case, okay? And I think this is one of Fred's cases, actually. Hospice Family versus Allen, okay? This is an important case and Fred lost it. But
Well, we knew we were going to lose.
But it's a going and coming it's a going and coming rule. It's a rule of going and coming case, okay? So you have somebody who's left work, goes on a personal errand, stops at the pharmacy or whatever it is, and is heading home when she's involved in a motor vehicle accident resulting in her death, okay? Now, normally, that is not going to be a compensable accident according to the going and coming rule. But in this particular case, according to the appellate decision, there was a determination that there was going to be an expectation that the worker was going to be working from home, had cell phone, laptop, pattern and practice of working from home and that sort of thing, which then made that entire journey hard and connected to the employment, okay? Now, I think one of the important things about this case is not only how it impacts the going and coming rule in Alabama, but it's also in this world of people working virtually from home. What does that do to our exposure there? Okay. If somebody is leaving their home office, going down the stairs to get a copy from their personal printer and falls down the stairs, does that make it compensable? If they trip over the cat and fall down and break a leg, does that make it compensable? If they're on the phone with a claimant while walking the dog and get pulled down and have a shoulder injury, does that make it compensable, Fred?
Yeah, and I'll tell you what happened in that Sharp case. I heard something Lane Kiffin said this week. Yeah, I love following this Auburn drama. And so Lane Kiffin says, oh, I'm not going to do coach speak. I'll tell you this. So I'm not going to do lawyer speak. I'm going to tell you what happened on Allen and Sharp. That was a death case. It's a nurse. She's going home. She's a traveling employee and she's on the way home and she's killed in a horrific accident. She's like a 25-year employee and it's a death case and she's a salt of the earth person. What did I tell you a while ago? Credibility of the plaintiff. Now, we couldn't, if we just surrendered, we just turn over $300,000 or ask the judge to decide. Here's what happens when you get into court. So we get into court, and this particular judge, who's now retired now, Thank goodness. I mean, I didn't say that. But this particular judge, he takes over the case. The plaintiff asked a few questions. I put on mine and all this, and the judge decides, for whatever reason, in my mind, my impression is that he had decided how he wanted to rule. So he starts asking my witnesses more questions. Well, wouldn't you agree with me? There's a possibility. This is the judge. Wouldn't you agree with me? There's a possibility she would have worked at home. Wouldn't you agree with me? She worked from home before. Wouldn't you agree she had the company computer in her car? These were a bunch of questions that they had barely gotten into. And the judge became an activist in the workers' comp trial. So you see, getting back to the point, that's how these things change. And so it's kind of like, we've got to say, what is the law? And then who is the judge? And then how credible is the plaintiff? Because all those variables have to be considered, especially if you can tell something is a disputed claim. Here's another one. Let me give you another one. This is another one. How much? You know, somebody told me that somebody was up here one year and they said they'd never lost a work comp case. That's what my dad used to tell me when we were playing baseball. He said, you know, all these guys that say they've never made an error, that means they've never played. He said, because you're going to play, you're going to make errors, you're going to play. He said, you find a guy that's never lost a case, you find a guy that's never tried a case. All right. Well, Clay, we've probably tried 100 or more between us, if not 10,000 total. But here's one. I took it on the face. I took a pie in the face. This is another new one. Green versus T.R. Miller. Here's the deal. This is turning the whole industry upside down on what the last injurious exposure rule means. Okay, what happened was this. We were paying a guy's medicals for RSD. I'm representing the guarantee insurance, Alabama Insurance Guarantee Association. The guy files a new suit with a new employer, T.R. Miller, and he says, I've got a new injury and my RSD has been aggravated. And he's represented by some good lawyers, Bruce Abels. I know y'all have had cases with the Abels firm down in Birmingham, in Montgomery, Abel and Brittany Bragg. And so they had this case. And so all we did was intervene to say, if you win, we don't have to pay any more medicals because we're out of it because of the last injurious exposure rule. Well, the trial judge ruled that he did not aggravate his RSD, and it was the same as it was in his opinion. Now, doesn't matter how he ruled. Here's the important thing. Abel and Bragg, they took the case up on appeal. On appeal, our Court of Civil Appeals said it's up to the trial judge. If the trial judge had ruled for the defendant in this case, we would have affirmed. This case, if the trial judge had ruled for the plaintiff, we would have affirmed because the trial judges in Alabama have great discretion. And so here we go again. Who in the world is your trial judge? And why is it so important to have a good reputation? And let me just say one other thing. I'll throw to Clay, get his thoughts on this. Do not ask your lawyers to do stupid stuff. If you make ridiculous arguments in court, or if you're in there with $100 issue and you're tying up the court time on it, you know, the judges think we're insane and we're ridiculous. You know, you have got to have credible arguments because we've got to keep our credibility with the judges. You will never win a work comp case unless you go in wearing the old Hoss Cartwright, the white cowboy hat, you know, that says you're the good guys as opposed to Black Bart over there. And when they have the gunfights, okay? So make sure you don't do anything crazy or ask your lawyer to do anything crazy. Clay, what's
you're right. So credibility, this is somewhat of a sad statement, but credibility and an effective attack of that credibility is one of the leading weapons that we have in the defense of a workers' compensation case. That's why good surveillance is so important. That's why it's important for the injured worker when the injured worker's deposition is taken to tell the truth. I mean, it's, you know, even in a situation where they'd rather not tell the truth. Okay. I mean, it's, not only are claimants more likely to lie in certain predictable areas, even when they know there's a chance they may get caught, there's often still a propensity to do that. Okay. A claimant may fudge a little bit on what their injury, how much their injury really does limit them. Okay. I know that's a shocker, right? So that's where surveillance comes in very, very handily. They will also hedge the truth sometimes when you're asking them why they were terminated from a particular job, because they don't want to admit they got fired. They think that it somehow affects their claim. And the truth is, it only affects their claim if they're being untruthful about it. They may tell you something that's untrue when you're asking, have you ever hurt your back before? Okay? Never mind whether they hurt the back before has nothing, just about nothing to do with your exposure and the quality of the case that claimant has in the current litigation. It is only relevant and is only hurtful to the claimant if they're not truthful about it. But here's what Fred was alluding to. Credibility is a two-way street. Okay. So if we take ridiculous positions, like we didn't get notice of the accident, okay, when we saw it, okay, or something like that, we have lost credibility with the court under those circumstances. When your lawyers are parading up to the court in a litigated case, fighting about stuff that doesn't matter, that also can turn into a credibility issue. I mean, keep in mind what we're trying to do and who our constituency is. The judge is going to be making a determination of the case. Everything that we do that is observable by the judge needs to be strategic and with that in mind and with our desired outcome in mind. So we don't take ridiculous positions. And what the judges hate more than anything else, by the way, plaintiff lawyers hate this too. Don't waste their time, okay? Now, you can have really good plaintiff lawyers in this state. Generally speaking, they don't mind a fight over a legitimate issue. They understand that. What they don't like and what has the risk of inserting emotion, which can be very destructive and produce unpredictable results, is if you make them fight about stuff that doesn't matter, okay? So we don't want the court addressing stuff like that, and we don't want the lawyer addressing stuff like that, because that interferes with the overall strategy of moving the claim along quickly and getting a favorable resolution. Fred?
Yeah, and along those lines, let's talk about when is it appropriate to be aggressive? And when do we need to, and here you got to kind of make a judgment call. And some of y'all, and I wish I knew who I represented, didn't represent, but you know, all of y'all are voices to me. I know very few of your faces. So some of you are out there though. And when is it important to be aggressive? Well, here's one thing I've noticed over the years. If you're sitting there and you got a file and you have a good faith argument to deny it, deny it. I have seen, and I've changed my position over this after all these years. I used to say, well, now if you get rid of it for I always say, if you get rid of it for $5,000 less, maybe in these days with inflation, rid of it, especially if you're closing medicals. But if you have a good faith argument, I've had claim after claim after claim over the years where they send me a file. They've already spent $75,000 on the medicals, $20,000 on the indemnity. And I talked to a couple of witnesses down at the store and say, hey, was there any question about whether he hurt himself? Yeah, there was a big question. We think the guy's a liar. You know, he's on cocaine. I'm like, what? What? He's on cocaine? I had one recently where two guys, while they're at work, stopped by McDonald's. They didn't get a quarter pounder. They got a quarter of fentanyl, you know? And I'm like, and then they had a wreck and wanted to claim workers' comp. And so my thought was, I don't know if it's covered or not, but we're not paying. We're just not paying. You tell the judge you were doing a fentanyl buy and you try to see if you're going to win. Because I know the judges up there and they're not going to do that. Okay. So there's a time to be aggressive. But I say this, you're going to get a better settlement. You'll have a better chance of closing all the medicals. If you have don't make it up. If you owe the claim, don't waste time. But if you have a good faith defense, at least send them one letter and say, hey, you know what, Bill? According to what we know, you know, you had left work and clocked out to take your grandson somewhere. So we don't think this is owed. If you got something you want to tell us about it, if you can get some more, I call it the soft denial. You know, it's kind of like breaking up with somebody gently, you know. Yeah, I hadn't done that in 40 years. My wife and I, you know, and all this is really a lot of this through your optics. It's like my wife and I, we're in counseling right now for this Alabama Auburn thing. And so I'm kidding. But I not that I've been in counseling, of course, but I do know they always say we're all looking through our own lenses, you know, And these judges are looking through their lenses, and you better have a good faith reason. And I'll tell you something else, not only, but you better have a good faith reason, but some of y'all in this room, I could, and I'll guarantee you Clay could too. I could probably name you 5 companies right now that the judges in Alabama can't stand that are workers' comp providers because they fight about everything. You'll have a guy cut in half and he's in the courtroom and he's still bleeding. They're holding him together and they'll go, well, we're not sure he's really hurt. You know, you see what I mean by a ridiculous argument? We cannot do that. The optics are bad. The judge is looking at that and he goes, and you know what they ask us sometimes? I don't, they ask me, who's the insured on this? You know? And your reputation will determine the response to that. I'm gonna brag on y'all, GSL, over the brag on home builders again, but I had one where we zeroed somebody out. They moved to set it aside and they said, Judge, this is Judge Little up in Huntsville. And they said, Judge, they always are trying to screw somebody out of benefits. And I remember the judge, he said, who is it? And I said, it's the home builders. And he goes, that's not my experience with them. Now, there's a couple of companies, if I'd have named them, I'm not going to. I'm not sure why. Better not. But I'm telling you, if it had been one of those companies, they'd have probably given the guy an award because those companies deny everything. And if you get that reputation, you're going to get cooked. Clay, what are your thoughts?
Well, this was the beautiful of the day of having the court approvals because we were up there regularly settling these cases. The judges knew who the TPA was, knew who the insurance carriers were, and knew who was settling those cases. That's not happening so much anymore. But Fred's exactly right. We need to covet that relationship. We need what we can to enhance it. And you know, so much of this is about understanding human behavior. I mean, it really is. And the work of today's modern claims professional is a work in psychology and to a great extent. Okay, if you've got a compensable claim, particularly if you've got somebody that hasn't had claims before, it's important for you to establish that level of trust with the injured worker. First of all, they're scared to death, at least initially. And that's a wonderful opportunity to tell them, look, I'm your claims professional. I'm going to be here for you. We're going to, here's what the plan is. We're going to get you to a good doctor. We're going to get you, if you need surgery, we're going to, you're going to have surgery. We're going to get you into rehab. We're going to get you back to work. That's the plan. They need to be hearing that message very, very early on. And they're hungering for somebody that is going to be kind of there for them. They can answer their questions and it's going to demystify this process. Okay. So as claims professionals, once we have established that relationship, once they get to MMI, first of all, what happens at MMI? We all know, but the claimant, even if that's their first claim, also knows something is going to be different now. This claim has just taken a turn and they're expecting something different. That is an excellent time to reach out to the injured worker and get that case resolved and prevent it from being sent eventually to someone like me or Fred. They're ready for it. And so if their rating works out to $4,000, okay, this is what it works out to. However, we want to get this wrapped up. And if you're in a position to accept this, I can offer you 3 times that much. And we can get this thing wrapped up for 12 and I can have a check generated and we can get this thing over with. Okay. If that relationship has been nurtured, there's a reasonably good chance that that case is going to get settled then. Okay. But if if you don't have that relationship and you're making an offer that to a layman appears or has the trappings of being too low or not fair, if they haven't been consulting a lawyer before, they certainly will be chasing the lawyer then. Okay. So this is all about speed. This is all about taking advantage of opportunities that are in front of us. Fred?
Yeah, and let me break the bad news to you just so get this in reports, you know the lawyer's telling the truth. We've got a bunch of case law now that says the trial judge can multiply the rating. We've got 4% cases where 50% was awarded. We have a 0% impairment with a permanent total award. We've got a bunch of 3 and 2% where they've given 30%. It's just reality. The trial judges have absolute discretion. But getting back on what Clay said, let's talk about speed for a second and getting these things moving. All right, here's a trade secret that Clay and I figured out. And I see some of y'all are in here, so I hate to tell this to them. The best way for us to get business from you is close files. It's get these things moving and get them going. Now, we've all got some. I've got some right now. They're stuck in the ditch. I'm putting my foot on the pedal and it just won't go anywhere. We've all got them. But if they're at MMI, I hate to disappoint us all too, not to run us all down, including me and Clay, but we are not inventing atomic weapons in this room. This is work comp. You run the numbers, you see what you owe, and you see if you can get rid of the claim. And there's no reason for claims to have a long life. And have you noticed this? They never get better until you settle. And then have you noticed that one of the best weapons at a settlement, and Clay and I've done mediations for each other too, but one of the best weapons is tell the guy, you know, I know you say you're permanently totally disabled, but if you'll take the lump sum, you can try to work next week. And I've been a mediator, I've seen him go, really? You know, and yes, really. And so the faster we get that moving, the better. Now, here's what I'd say. Here's a novel idea. I think some of y'all figured this out too. And an attorney told me the other day, the new complaint is the letter of rep, because some of these attorneys will not talk to y'all, but they will talk to the defense attorneys, unless we've been jerks. But if we haven't been jerks, they'll talk to us and we'll say, like a guy called, yes, just this week, I got a lawyer, he's writing and he's threatening outrage. And you know, I know this guy. I've known this guy for years. So I picked up the phone and I said, what are you doing? I'll tell you right now, 14 reasons why this claim is not owed. And it's not outrageous to deny a claim anyway. And he goes, well, okay, I guess I got carried away. See, nip it in the bud, speed, nip it in the claim. Do not keep them going forever, and make sure you close medicals every time you can. One more nightmare story, and then I'll let Clay. It's a case we had in Mobile several years ago. I got a call in 2016. They had settled it in Mobile for $4,000 non-surgical back injury. I got a call from the excess carrier and they said, can you do anything to help? We're at $990,000 on the claim. And I said, for what? And they said, medicals. They've been piling up over the years and it could have been settled. The medicals could have been easily settled in 1996. And the paperwork, and I'm not saying this is malpractice because I don't think it was in, but when medicals stay open, you better describe the injury with specificity. In this case, the injury settlement documents just say something like hurt his back. And then, you know what happened? Here's a shocker. Not all y'all stayed with the same companies. The file got passed around. They got new TPAs. The two TPAs got new adjusters, and all they do is read back. And pretty soon they were paying for every problem that woman had, and it had nothing to do with the original injury. Could have been ended in 1996 for probably another $4,000 and saved $1 million. And we did get it resolved because all the doctors said, yeah, none of this is related, but nobody ever stopped us. You know, so there you go. Clay?
Exactly right. So even if you get a letter of representation, okay, that is not the end of the world. Okay. So what has happened over the years is a larger and larger and larger percent of the work that I do and Fred and other defense lawyers is really pre-litigation stuff. Okay. So just because you've got a letter of representation and you say you're at MMI, you can still get that case ended very quickly. I mean, we've got some excellent mediators in this state. We've got a good ombudsman program in this state. We can go ahead, you can have that case evaluated by your lawyer, set it for mediation, and have it ended over before litigation, okay? I mean, keep in mind speed. The faster you move, the less legal spend you're gonna have, number one. And number two, it tends to be a smaller claim. Even if the case is in litigation, there's still things that we can do in connection with working with your defense lawyer to move the case along quickly, okay? I mean, if you have a compensable surgical shoulder, 4% full duty release lawsuit, what is it that we're litigating? That case needs to be settled. then that I would suggest that that case can be settled without taking the plaintiff's deposition, without doing anything. Set it for mediation. You can still do that. And think about human behavior, okay? So now that case is in mediation. Injured workers there, first claim, we get an opportunity to settle the case, X number of dollars are on the table. Take that, mediator says, because if you don't take what they're going to offer, there's no telling when you'll see that again. And this lawyer is in the business of finding out everything there is to be found out, and they will. And it may be a year from now before you have an opportunity again. That's a powerful dynamic at work to get that case over. And it works in the pre-lit case just as well. We have an opportunity to get it resolved. If we don't take this opportunity, it's going to be gone. This is why I like mediation. Look, I like to think I'm a great negotiator. I really do like to think that. But I will tell you, I've had better success at mediations, because what I can do at mediation is, and it's not necessarily me, it's the process itself that creates this sense of urgency that this is my opportunity and I need to take it. Fred?
Yeah, and at the mediation, one thing you can do, remember, it's not a sin to not settle on the day of mediation. In other words, we have so many of these that settle within the next 10 days after the mediation. Sometimes, and again, this is a human behavior issue, and you need to work with your counsel on this, but sometimes you're a lot smarter and better off if you just say, look, 10,000's it, we're leaving. I was mediating a case in for two attorneys in Huntsville. I was the mediator. All right. The defense attorney said, I'll offer 5,000. They said 130. And then he said, the defense attorney told me all I've got is 10. So I went and I said, look, they say all they've got is 10. If you can't get down to 10, I think it's over. He goes, we'll never take that. Tell him our low offer is 75. So I went back in, I said, his low offer is 75. And he said, okay. He said, well, all I got is 10. And I said, well, take off. So I go back upstairs to the plaintiff's attorney and I said, okay, he's gone. He said, what do you mean he's gone? And I said, well, all he had was 10. Well, we want to think about it. And I said, I thought your low offer was 75. And he said, let's think about it. So he goes, stop him. So I go back on the head, he said, stop. Then the plaintiff's attorney comes back to me, we'll take the 10. You know, I'm like, sometimes you just got to walk out the door. Just leave. It's not a sin. They can always call you next week. Here's the famous thing you can always say. You can say, hey, all I got today is 10. I might be able to get another couple $1,000s if you can get close, but it'll be next week before I can get it. And then let that guy think about $10,000. And I'll tell you another thing too, I like is the cash presentation. You know, everything's about presentation. You've seen the meals. One hamburger looks this way and another one looks that way. And it has nothing to do with the hamburger. It's all about the plate. But when you're mediating a case, it is so good if you don't nickel and dime them too much, but pick the right opportunity to walk in and go, they've offered $10,000. And you can see the plaintiffs light up $10,000. And of course, you know, you don't pay taxes on this, really, you know. I'm just telling you, it's presentation and it's human behavior and it's reading people. Clay?
Okay, so we stopped talking about cases, if you notice, thank goodness. And we're talking about strategy. So let's talk about the panel, okay, and panel strategies. Okay. So injured workers entitled to one-time panel, period, paragraph. Okay, there are some exceptions you can articulate, and I've done it before a couple of times where we say, you know, treatment's over, we don't know a panel. Okay, you can technically make that argument. It's a loser most of the time. The real, and this is in terms, this is claims management. Okay, it is almost always, if they want a panel, and they're going to want a panel, it is better to have that panel spent early in the process. That will give you more long-term control, and it's going to end that claim theoretically sooner. Okay, if they treat for 5 years and they haven't asked a panel, and then they're released and now they're asked for a panel, you probably owe them a panel. Okay, and that process can start over again. So if you have them on the phone and you're doing what you can to enhance that relationship, and they're saying, I really don't like my doctor, or he's not listening to me, or she won't do this, or whatever it is, saying, you know what, if you'd like, I can give you 4 doctors and you can make a selection, you can pick the one you want. Okay, I'll do that. Now, you can ask me, you can ask Fred, and we have some ideas about who ought to be on the panel, okay? It may include or not include Dr. Kevorkian, just depending. But if you want to have a good panel, okay, that's probably likely going to involve nurse case management involvement. Because you want a nurse case manager normally, there are exceptions, okay? But if you're at a panel stage, particularly if you've got a full release, no impairment situation, you want to make sure that your selected panel doctor is singing from the same sheet of music, okay? And you can do that effectively with a nurse case manager who can educate the doctor. And by the way, here are the records where he says that, okay? But you're leveraging that relationship. That's what it's about. So the nurse case manager is going to say, okay, here's who I think are the orthopedic surgeons that need to be on the shoulder panel. Because theoretically, the nurse case manager is going to know each of those people and be able to communicate with them. So that's what you want. I'm not talking about somebody going to the internet and picking them, okay? I'm talking about picking people that they know. And that's going to help you. That's going to help move that case along much more quickly. You agree with that, Fred?
I do. And just a couple of things on nurse case managers. Number one, always remember the rule. Your communications with your nurse case manager, your communications with all these vendors out here are not subject to a privilege. All right. They're not protected like if you talk to your lawyer. So make sure that you don't say anything improper, and particularly you don't put anything improper in writing. Just this month, I've gotten 2 letters on new assignments where for whatever reason, the adjuster has copied the case nurse on the defense assignment. And I'm like, well, there went the attorney-client privilege, because if you have the third person in the conversation, there is no attorney-client privilege. So make sure that you realize when you're dealing with a case nurse, it's just like talking to a doctor. In Alabama, under Alabama law, they are a medical provider and they have a fiduciary relationship to the patient. And it's particularly a dangerous thing when they work for you, or if they work for the company who's the insured, they better be disclosing all that. There was a case in Athens just a few years ago. The adjuster did not defend, neither Clay nor I were involved in this. The adjuster and the case nurse were sued for breach of fiduciary and conspiracy to put a guy back to work too soon. And a jury in Limestone County brought back $100,000 award against the adjuster individually, because there were emails where she said, I want this guy back to work. This claim's gone on too long. You tell the doctor to get moving, and things like that. And a jury's like, well, they're trying to defraud the guy out of benefits. $100,000. Second thing, third thing on case nurses. And I'll see if Clay agrees with this. I get this question. Sorry, if you're a case nurse, I'm sorry. I mean, just, I'm not going to do lawyer speak or coach speak, as Lane Kiffin would say. But you don't need to send the panel. You help us get the panel. Let the adjuster send the panel letter, because the case nurse has a fiduciary duty to the patient. The actual assignment and the final decision needs to come from you. You can get your lawyer to send it. You can send it. But you don't want to drag the case nurse into becoming a claims adjuster. And I'll tell you, it's a lot of them want to be claims adjusters. I've noticed that. And I tell people, don't use a case nurse. You do not use a case nurse that doesn't know the difference between adjusting claims and providing medical care, because it's 2 separate matters, and you got to be careful. Because these things, you know what happens when you go to court? You get one of those emails like that. You walk into the courtroom, you see this thing up here. Hey, it's me. You look up there. Wow. I'm looking in the mirror so I can see what I look like. You get that, you'll come in and there'll be your email blown up like that. There'll be a giant thing where they said, get him back to work too quick or something. And that'll be like this thing sitting in front of the judge the whole trial. I had one where a guy had a needle in the eye. I bet as much as I could take. Plaintiff's attorney blew it up. There was a giant eyeball with a needle in it. And we watched that the whole trial. Okay, I think I took one on that one too. Clay?
Well, I agree. So, I mean, look, your lawyers are in part marketers. Okay, we're in part marketers. Okay, you are in part marketers in your business. Okay, when it comes to the clients we're dealing with, claim reviews and all that kind of stuff. Well, nurse case managers are in part marketers as well, and so we need to. So there's a desire to get a good result so that they get additional assignments later. I understand that perfectly, but we need to keep in mind about what the limits are, and so. It's not probably fair to have, and you shouldn't have dialogues regarding privileged information like surveillance and whether we ought to do it with a nurse case manager, because that's going to be discoverable every single time. And plaintiff lawyers are already highly suspicious that there's a conspiracy going on anyway, okay? And, but the best nurse case managers, I think, are two things at once. They are an advocate for the claimant with respect to getting medical care for the injury in question, and they're an advocate for the process to get it going quickly and return that person to work. Okay. Now, the claimant may or may not be on board with strategy number two, but your good nurse case managers are. Okay. The other area you can use the nurse case manager is that we're seeing more and more joint replacements. Okay. So the reason for replacing joints by and large is pre-existing profound arthritic changes. A simple clinic note entry can really change the dynamics of a case. If the purpose of the joint replacement is to address pre-existing arthritis, that's one thing, and that's good. If it's because they had a meniscal tear and they still have pain and relating to the original accident, you've just added $150,000 in value, medical and indemnity, to that claim. Fred?
Yeah, I've got a doctor right now who will tell your oath that no total knee replacement is ever related to a work comp injury. It's a thing that developed over the course of their life. It will not happen. If you need the name, I'll tell you afterwards on the break, but he's just adamant about it. It's an occupational doctor and he's really good. Now, one other thing I'll mention to
Fred, it's 1:59.
I know, we got 1 minute. As I said, one other thing, venue. We had a new case on venue, ladies battling on whether they'd be sued in Jefferson County or whether they'd be sued in Tuscaloosa County. They wanted to be in Tuscaloosa County. The plaintiff wanted them in Jefferson County. That case went back and forth until finally the Supreme Court of Alabama overruled the Court of Civil Appeals and overruled the circuit judge and said that case had to be brought in Tuscaloosa County. And to make a long story short, I was doing the judge's case law update and I said, I was just kind of kidding, but I said, well, this sounds like politics. 80 circuit court judges, they just broke out laughing. I'm thinking there is politics in this stuff. Anyway, we're tied of time, I think. Clay, anything?
That's it. No, I can't improve on a discussion on venue.
Okay, we're done. Thank y'all.
Thank you.